Morning, everyone. My name is Pete Boulain. I'm the 2024 president of North San Diego County Realtors, and I want to express my gratitude to each of you for your commitment to the real estate profession by attending this update on commission, compensation, and the MLS. Your dedication to staying informed and engaged is truly commendable. As your association, we are committed to keeping you informed of the latest developments regarding the NAR settlement, new laws, and the California Association of Realtors new and revised contracts. We continuously offer webinars and in-person events to ensure that the information you receive is up to date as possible in this ever-evolving field. Notably, the forms that were previously postponed were released this past Wednesday on July 10th on car.org. They'll be available on zip forms starting July 24th, and the changes will go into effect on August 13th. We do have a few more free upcoming webinars you might want to attend. Residential listing agreement on Monday, July 15th. Residential purchase agreement Monday, July 22nd. And the buyer representation and broker compensation on Wednesday, August 7th. So stop by nsdcrealtors.com, check out the education calendar, and sign up for those free webinars. In addition, CAR will be offering 2 new classes on settlement-related forms, a buyer representation form class and a residential listing form class. Members can access the classes for free by logging into store.car.org, and additional resources can also be found at smartzonecar.org. Okay, we are privileged to have 2 of the industry's most knowledgeable speakers on today's topic, Ed Zorn, Vice President and General Counsel of CRMLS, and Chris Hasvold, CRMLS Chair and Broker Owner of Coldwell Banker Village Properties. Please post all the questions in the Q&A, and we will address these at the end of the session. So without further ado, I will turn it over to Ed and Chris. Thanks.
Thanks, Pete. Thank you, Shirley and the team, for putting this presentation on. Obviously, it's timely and important. There are lots of things going on in the industry, and it's really difficult to keep up with it. So we really appreciate the association's efforts to do so. As Pete mentioned, I am a broker owner of Coldwell Banker Village Properties. I've been in the industry for 44 years now, but I'm also, in addition to managing broker, I am a selling agent like you guys. I'm out there representing buyers and sellers every day and using these forms every day. As he mentioned, I'm also board chair of CRMLS, have been so for the last year and a half, been on the board for 6 years. So we have a pretty good insight into the litigation that was filed more than 5 years ago. We've been on this since the beginning. Also served on the board of directors of CAR and for the last 6 years, and 2 of those years were on Standard Forms Committee, the wonderful committee that creates and modifies all these forms. And unfortunately not on there right now, which is a break, although I was on during the PED years when we had COVID. So that was interesting. Before I introduce Ed, want to highlight a couple things that Pete said. Number one, the forms that are released are the draft version. They are probably not going to change much, if at all, but they're still a draft version. And as he said, use the Q&A rather than the chat, please, for questions. We will be monitoring the Q&A, but please let Ed do his presentation first. It's probably going to be about 25 minutes because I think he'll answer most of your questions. And then we'll have plenty of time for questions after that. As he mentioned, we are recording this, so you will be able to come back and see it at a later time. Little timeline here. CR releases new forms and revisions twice a year in December and June. There were 67 forms that were either new or revised, scheduled to be released on June 25th. However, on June 21st, we were notified by CAR that 19 of those forms, really anything that had to do with brokers sharing commissions, were pulled back. They would not be released. And that was primarily because the Department of Justice sent a request, their version of a subpoena, to CAR to look at those forms and see how the issue of broker sharing commissions was going to be handled. So those forms are now the ones that have been released on Wednesday. They were set out, and they will, on August 13th is when CRMLS will implement these rules. This is not a forms training class per se. We're not going to go, we don't have time to go through the 19 forms that have been released. We're going to talk about some of the ones that are MLS related, because the NAR settlement terms required multiple listing services to enforce the settlement. So we're going to talk about those specifically. And although CR has their forms, CRMLS has their forms, there's a couple that are not quite in sync yet. So we're still working on that. Hopefully that'll get resolved by the time August 13 rolls around. Two more things I need to mention. Number one, although I am a broker, I am not your broker. Whatever advice you get today or whatever you hear today, please make sure you filter it through your own broker. Ed is also not your attorney. He's the attorney for CRMLS. So if you have any questions, make sure you either call the CR hotline for legal questions or your broker counsel. So a little bit about Ed. Yes, he's Vice President General Counsel of CRMLS. I've known him for probably 6 years now. And I will say he's probably the smartest real estate attorney I've ever worked with. His analysis has been spot on from the date these lawsuits were filed, predicting really what was going to happen and how this was all going to play out. Well, for several years, others didn't want to acknowledge that. But he is also a CCIM, which is a very special designation for commercial brokers. He's also a licensed residential broker, and he's out selling homes. He's using these forms like we are. Although he's in Tennessee, he knows these forms. He's in the business. So he has a special insight to what we do that most real estate attorneys don't. So you're getting a really good presentation from someone who knows not just the law, but knows how the transactions work. So with that, Ed Zorn.
Hey, thank you. I appreciate that wonderful introduction. Chris, it's been wonderful knowing you for 6 years, and thank you for all the service you've devoted to CRMLS, and the growth we've experienced under your leadership has been really great, and for leading us through these very challenging times, but sometimes, kind of fun. Lots going on. Certainly not boring. So with that, I'm going to talk a little bit predominantly about the changes that are being dictated from the MLS perspective and the impact on you as boot on the street practitioners coming up. And that the big date is really August 13th. So Chris did a wonderful introduction. And as we kick off here, I want to kind of level set your mind into the right philosophy. And someone asked Wayne Gretzky, what makes you such a great hockey player? And he responded with this quote. We've all heard it, right? Skate to where the puck is going to be, not where it has been. And that is so true today as we talk about these subjects. We're going to talk about how you get paid is changing. How you interact with sellers and buyers is changing. And it's okay. There's great opportunity. Everybody's still going to get paid. Things are just going to be a little different. And so it's really important to focus on what's next and what to do next, rather than spend a lot of time, energy, and effort complaining or whining about the past. It's not going to change, guys. These will be the new rules. This is how it's going to work going forward. And the faster people embrace that, understand how that works, and then start to do the process of training their processes and systems to comply with the new systems, the more market share you'll get, the more satisfied clients you'll have, the more referrals you'll get, right? So good time for opportunity. So two major things are happening that are going to impact you directly. And they both happen on August 13th. The first is that under the terms of the settlement agreement and the NAR MLS policy, CRMLS will be removing all compensation fields from the MLS. That means the BAC field, right, will be gone. You will not, if you go input a listing on August 13th, there will be no place to input an offer of compensation. The other big thing that's happening on August 13th is that before you show a property to a buyer, potential buyer, you will have to have a written buyer representation agreement in place. And there's some details around that will cover that. These two elements attack the core problems that were alleged in the lawsuit that the industry lost last November, and the criticisms from the Department of Justice and the consumer advocates about the process of making offers of compensation and the negative impact that that may have had on consumers. And so NAR has agreed to these changes, and we as MLSs are required to make these changes. So I want to go through them in a little bit of detail and explore exactly what is changing. So the first one, again, dealing with the no offers of compensation on the MLS. This is the actual rule, Rule 7.15. It is more than just we took the field away. You may not offer compensation to another agent on the multiple listing service anywhere. That means you cannot put it in the agent comments. You cannot put it in the property description. You cannot put it into your showing instructions. If you use a showing time or some other showing platform, you can't go in there and type in, hey, before you show the property, I want you to know this is what we're offering, right? You can't upload a document into the supplement section that has this description of how you're sharing commissions, right? None of those things will be permitted, and you will receive a fine for that in fairly short order, okay? So one other aspect of the rules that are changing is that there is I'm not going to call it an exception, but a guardrail that was put on us MLSs. So if you look at the overall structure of the NAR settlement agreement, the agreement requires us as a multiple listing service to do 13 different things, 13 affirmative things that we have to do to effectuate the practice changes anticipated by the settlement agreement. Some of those were technology-based, remove fields. Some of them are rule-based, like the rule we just looked at, and have to do with enforcement. One of those rules has to do with licensing, right? About the fact that we are no longer allowed to give someone a data feed of the listings if that website is going to display offers of compensation. Then we are required in the settlement agreement to terminate that data feed. There is an exception to that, and that is taken up here in our Rule 19.2.21. Rule 19 deals with our licensing, and it specifically has to IDX that on your individual website for a broker, you can display an offer of compensation only on the listings that are listed by the brokerage firm, right? So that is a small exception to the rule. I have no idea why you would do it. It's actually not accommodated well with the new changes in the forms. We'll talk about that later, but it is technically something that's available. Do you want to spend some time on this particular rule? This is probably the one that's going to be the most impactful to you, especially those of you that represent buyers. And in my opinion, this is also the rule that is really going to drive the most consumer protection against what was alleged against the industry with regard to steering. And so that is the requirement that before you show or tour a property with a buyer, you will have to have a written agreement that contains these 3 specific terms. The agreement is going to have to identify exactly what you're going to get paid, either a dollar amount or a percentage or some kind of description of exactly how that's going to be ascertained or calculated. You are also not going to be able to receive more money than what that agreement calls for. And by the way, obviously this makes perfect sense. Did anyone pay a CPA to do your taxes, right? Coming out of the last tax season? How many of you got a bill from the CPA that you hired him to do your taxes? She did the taxes exactly like you expected, and they gave you a fee, a bill that was 35% more than what you agreed to, right? None of us would pay such a fee. And so this kind of makes sense that, if you agree at the beginning of a relationship with the buyer that you're going to perform a certain set of services for that buyer at X%, then you're going to get X% and you shouldn't get anything more than X%. That's what you guys agreed to do. Okay. So that's a requirement that has to be in this agreement. You also have to have the typical statement that we see everywhere, that we've seen for decades, frankly, which is that the broker fees and commissions aren't set by law and they're fully negotiable, right? This is something that's been sitting in all of our documents for a long time. There's one last sentence of our rule that's really important as it comes to this dealing with buyer representation agreements at showings. And that is, this rule applies only to buyer agents, buyer brokers representing the buyer. It does not apply at all to the listing agent or the listing brokerage firm, right? So think about it this way. When you enter into a listing agreement with a seller, that seller is giving you written permission in a direct agreement between the listing broker and the seller for the listing broker to open the front door, for the listing broker to tour and show people through the property. So as a listing broker, you get all of your permissions to access someone's property through this agreement you have with them. Well, when you're a cooperating broker, right, when you're representing a buyer, you have zero relationship with the seller. You've never met them. You've probably never spoken to them, right? So why do you, as a buyer's agent, get to open up some stranger's front door that you've never spoken to before? The reason and the authority that you have comes directly from the multiple listing service rules, right? And so that's the rule that can put on you a condition on having this written agreement before you open that door. So if you're holding an open house as an agent, listing agent for the listing firm, you do not have to have a buyer rep agreement. You don't have to have anything signed at all, right? If you get a call off of your sign or a flyer or some internet ad, as the listing agent, you can go into the property with that consumer anytime you want without signing anything, right? Again, because your permission comes directly from the aspects of your listing agreement. That's different than the buyer's agent who has to have a written buyer rep agreement before they open that front door. Okay. Another thing I think that's coming out there as we've removed compensation is CRMLS has added a new field that we did back in May called concessions in price. And this process actually started back last year. In fact, Chris was at the meeting in October of 2023. The meeting, by the way, that happened before the trial that resulted in a lot of these things occurring. And we had a rules committee meeting where we talked about concessions. And as you know, at CRMLS, we have required the reporting of concessions for a very long time, for decades, in fact. And the way you report concessions is you report them on a closed listing, you put in just a dollar amount, and there's a text box where you can then describe what kind of costs or expenses did the seller pay on behalf of the buyer, right? And we've always had that. So as we started exploring what's going to happen with these changes, we kind of took a look at these concessions that have been reported, and we were really surprised. We've discovered that in 2023, 40% of all closed properties had a concession. That's a giant number. And when we did a little bit of an even tighter look, when I looked at Riverside County in May of 2023, and 64% of the FHA properties that closed, right, where someone identified getting an FHA loan, had a concession. And those concessions were 1.8% of the purchase price. Now, keep in mind, while all of these concessions were happening, we still had full offers of compensation. None of the money for concessions was going to pay for a buyer's agent. None of it. None of that 1.8% went to a buyer's agent. It went to pay for other costs and fees that a seller was willing to pay for a buyer to get the buyer into the property. So we thought, it makes a lot of sense that a seller should also be allowed to advertise this concession concept to communicate that, hey, this list price that I set anticipates me paying and helping a buyer in this fashion, okay? So concessions are very different than compensation, mainly because it is the buyer who gets to decide how to spend the concession. It has to become part of the purchase agreement and has to be negotiated between the buyer and the seller. That is completely different than offers of compensation, which are between the two brokers and which happen automatically under the MLS rules with no negotiating happening at all. So very, very different situations. And as we've rolled out these concession fields, this is how you can use the concessions to try to drive more traffic to your properties. And again, I think they're best used in that entry-level homeowner situation. And so we have a concessions in price. It's a box where you can put in a number, and then you could assign either a percentage or a dollar amount to that number. We also have just a yes/no field, which is you can communicate to the buyer population that your seller is willing to consider a concession without committing to any number at all, right? And so you could just say, yes, my seller is interested in in entertaining an offer for concessions, but we're not going to pick a number. And the reason that's important is as we go into this new world, I, as a buyer's agent, I need to know, did the listing agent have a good conversation with the seller? Did the listing agent prepare that seller for the reality that I'm going to enter into a buyer rep agreement before we show the property? The buyer and I are going to establish the fee that I get paid as the buyer's agent before we ever show the property. And then I'm going to ask the seller to pay for that fee in the purchase agreement, right? That's going to become the new norm. And I want to know, did the listing agent have that conversation on? Is that prepared? Is that part of the price that they set? Was that anticipation? Yes or no, right? So that's why we wanted to make sure we gave you this communication tool to work with one another. So inside of Paragon, here's where that shows up, right, on the listing input module. And again, it's a concessions and prices where you would type in a number, the type is just a percentage or a dollar amount, and then you have that yes, no button. For those of you that might be in Matrix, right, this shows up on the basic tab. It's right under the list price section, same exact fields, right? So very easy to get to, very easy to use. So here's some interesting statistics, right? This has been live for 40 days. And please remember, we still have offers of compensation, right? You can still put an offer of compensation in the system until August 12th. So for those people who are trying to argue that, hey, aren't concessions just a replacement for commissions? We actually have documentary proof that that's not the case because we already still have offers of compensation. In fact, of the 58% of these listings that chose to utilize this concession field, 98% of them are still offering compensation. So again, the concessions is not a replacement for compensation because these agents are doing both. They're offering compensation to the buyer's agent directly, and they're communicating a willingness that the seller will consider other concessions that have nothing to do with the buyer agent fee. Okay. In fact, we have more than 24 listings where the concession is 5%. 5%. Those listings also are still offering compensation. So what the sellers communicating on those listings is they're willing to spend an additional 5% above and beyond what they're willing to pay towards a buyer's broker fee to help a buyer get into their home. Guys, that makes sense on an FHA property, right? Isn't the cap 6%? Right? So it makes sense that we've got a group that 5% makes sense, right? And another piece of evidence to demonstrate that these concessions are not a replacement for compensation is by looking at the percentages of people who provided a dollar amount. So of the half of the people who did pick a dollar amount to put in or a number to put in, 20% of them used a dollar amount. So if you get rid of the 50% that didn't specify a dollar amount, right? They just said, yes, bring me an offer with a concession. We're not going to commit to a dollar amount. If you take that pool that did commit to some kind of an amount, 40% of them put in a dollar amount, not a percentage, right? So we have some very good usage of this field. The usage of the field is communicating the willingness to spend more to help the buyer than just the buyer broker fee, okay? Staying on the concept of concessions, one of the things that's going to be really important for you guys to understand as you move forward in this new world, where there's no automatic amount of money that is being given to the buyer's agent. For the first time, buyers are going to be competing or evaluating what is a buyer's agent going to charge, right? Most of us in the old world didn't have conversations with our buyers before we showed properties as to how much money we were going to make. Because under the old system, I didn't know how much money I was going to make, right? It was like, I've gotten paid all kinds of dollar amounts between 1.5% and 5% as a buyer's agent in the last umpteen years, right? I didn't know how much money I was going to make at the beginning of the relationship with the buyer. That is all changing on August 13th. Buyers are going to ask, and you have to commit to a fee. So the first time there's going to be competition on price on the buyer agent side. And the reason that becomes important then, as those transactions go to finding a property and offers get made, we fully expect that what's going to happen is the buyer is going to include in the purchase agreement, in the offer, a statement that says seller to pay buyer's broker X% of the purchase price at closing. In fact, at CAR, we have a form for that, right? It's the SPBB form and G3 on the RPA, right? So there's a whole system for you as a buyer's agent already created in the forms to get your fee paid directly by the seller. Well, here's something that's super important for you to know. And that is when you start using that transaction as a comparable property to try to determine as a listing agent what to price a property at, or as a buyer's agent, what kind of offer should you make? You need to know off of those comparables. When you see a sale for $1 million, we all know the seller never got $1 million. We need to know, what did the seller actually get and what other costs did the seller pay on behalf of the buyer, right? So we're modifying our existing concession reporting field from 1 box to 5. And you're going to tell us the closing costs, right? That's title and escrow fees, right? Did the seller pay for any of the buyer's title and escrow fees? Did the seller pay for any of the buyer's repairs or updates? We're calling that property improvements. Did the seller pay for any of the buyer's loan origination points or loan discount points, right? That number would go under the financing costs. Did the seller pay any of the buyer's broker fee, right? And so we have a column for that. And then another, we still have comments so you can, give us a description, like what kind of improvement was, paid for and why, right? So we can communicate with one another. So now we as agents, as part of the MLS, we know how to make the proper adjustments as I look at that property in the future and compare it to the subject property I'm trying to evaluate. Now I will be able to make an accurate opinion of value by having some more details around that closing transaction. Okay. So
and remember, it's to clarify that is just on the buyer side. It has nothing to do with the listing agent's commission.
Correct. We've never collected the listing agent's commission. We never will. In fact, there's a specific rule in the MLS that forbids us from doing that. So the concessions are defined as costs that the seller paid on behalf of the buyer. So they're the buyer's costs that the seller paid. Okay, that's what a concession would be. Not with, and we do not collect whatever costs the seller incurred for themselves. We don't care because that doesn't impact the value. Okay. So a little bit about July 24th and the new forms. The one that impacts us at the multiple listing service is the RLA, the residential listing agreement. And so CAR has made some substantial changes to those forms from what they were published before. And the biggest change is no commission sharing. The previous version of the form, 2C2, paragraph 4B, have all been taken out of the agreement. There is no sharing of commissions between the listing broker and the buyer's broker. Okay. That means there's no offers of compensation, right? If you're going to use the CAR residential listing agreement form, you're not going to be able to put an offer of compensation on your website because the form doesn't accommodate any kind of offer of compensation going from the listing broker to a buyer's broker, right? That's not how the form and how the transaction is put together. What this means is when you go into a listing presentation and you talk to your seller about commissions, the only amount of money that is being set at that point in time is going to be the amount of money that the seller is going to pay you, the listing broker, for your services and representing the seller. That's the only dollar amount that's in there. Now, as a good listing agent, you should have the conversation with your seller about how buyers who see their property are going to enter into a separate written agreement with the buyer's agent. And the buyer is going to commit to pay a certain amount of money to that buyer's agent, and that there's a strong likelihood that the buyer in an offer is very likely to ask you, the seller, to help the buyer get that fee financed by the buyer. And how the buyer finances their fee that the buyer pays the buyer's agent is by wrapping it into the transaction, by putting it into the purchase price. So the seller needs to be available and understand that. And you as listing agents need to start making adjustments for offers of compensation, right? And concessions in your CMAs so that your seller knows what portion of this closed property that we're looking at as comparable that the seller never get. There's a portion of money the seller never got. The seller used that money to help the buyer get into the home, right? And you need to have that conversation during the listing presentation. So when you get an offer that has a request to pay some of buyer's costs, the seller has already anticipated that and is ready to receive that and to deal with that and how they've decided to market the property. Right? Another thing that the CAR is doing is they are sunsetting. You will not have access any longer to the broker compensation, the cooperating broker compensation agreement, the CBC, or the anticipated broker compensation disclosure, the ABCD. Right. So for decades, we used the CBC to share commissions between brokerage firms. That form will be gone because the concept is you're never going to share commissions with another broker. Right. That's not how this is going to work anymore. The buyer's agent and the buyer's broker is going to get paid in the transaction through escrow, just like they do today, directly from the seller. But that request is going to be in the RPA. It's going to be part of the offer and the transaction process. So CRMLS has a lot of resources. And this is a page that we're keeping updated as additional events unfold. And with that, I'm reminding you that although we are recording this on July 12th, 2024, if it's any day after that, there could be other changes. Some of the things I said today may be different because of the ongoing nature of these issues. So I encourage you to look at that QR code, regularly go to this CRMLS resources on the NAR proposed settlement page. This is where we're dropping training material, FAQs, some short videos that Art and I have done, on these subjects. Okay, so super important. And that is now where we are now getting to come up and jump into our question time. So.
Okay, so before we do that, a couple comments I want to make. And I hear this all the time being part of CRMLS is that why are you guys being so forceful? Why are you initiating all of these things, right? This was not anything that CRMLS wanted to do or to be in charge. It is simply a response to the loss of the litigation and the onus of the settlement being put on the MLS, right? There's no choice but to enforce these rules. Okay. The distinction between concessions, I think, is really, really important. I know that Ed talked about it at length, but the difference between a listing broker sharing a commission with a selling broker is not the same as a seller offering a concession to a buyer who then can choose to use that money however they want, whether it be pay their broker, buy down interest rates, repair the home, whatever. That's a whole different deal because that's negotiated between buyer and seller. That's not between brokers. And that's, if you get nothing else out of this, that's really important to understand that distinction.
Excellent. Well, thanks, Chris. Thanks, Ed. We have a bunch of questions I'm going to rattle off to you here. And then some of them, Ed, you did answer, but then the question came in after you answered it. So obviously there's some confusion, but let's just get cracking, okay? Multiple questions were in regards to existing listings. If you have a listing right now, do you have to cancel it? What about the compensation field? Is that going away? Do you have to, is there a modification of terms? What's the appropriate way to handle that?
So I'll address the MLS way. And Chris, do you want to do the forms side of it?
Well, actually, no, and that's something I forgot. Remember, this is not a CAR forms training class, right? You're going to have lots of opportunities through CAR. The CAR attorneys will address that. Because CRMLS is required to enforce this, the CRMLS rules have changed, and how they relate to the CAR forms is kind of what we're addressing today. But I encourage you, for CAR questions on the form itself, that you contact or you take the classes that CR is offering. How's that?
So, yeah, that's good. So let me go with what's going to happen to your listing in CRMLS. Okay. So on August 12th, if you have an accepted contract and you've gone in and changed the status to pending or active under contract, okay, what we're going to do on August 12th, that night, we are going to shut off your access to the compensation field, the BAC field. It will be gone. You will not be able to edit that. But the number that you put in, and that is subject to your current active transaction that you're in, will remain in the box. So if when you go into the listing that is pending on August 13th, you will still see a number, the number that you put in, under that field. Okay. Now, if you have an active listing, if you have a listing incoming soon, or hold, or withdrawn, right? What we consider in the MLS, what we call a non-finalized listing. On August 12th, that night, we're going to go in and we're going to remove whatever number is in that field. And we are also going to lock down your access to that field on the add edit module, so you will not be able to change it. So you're going to go from whatever number was in there to 0 or nothing. And in those cases, on those listings, you do need to modify your listing agreement. CAR has a form that is already available to you for this issue. As Chris said, you can go to CAR to get the resources, how to use that form, right? But if that's the situation you find yourself in, you do need to modify your listing agreement with the specific form that CAR has created that explains this change that has occurred. Now, all of the historical listings, the ones that are closed, those are going to retain and keep the historical event that happened, right? That happened. We're not going to take that away from you, because you need to have what happened in the past, what happened in May, June, and July. You're going to need to do your CMAs in August, September, and October, right? So that you can give proper advice to your sellers and buyers on valuing property. And part of that is how much of that price of the home that was paid went to, that did not go into the seller's pocket. And then how does that impact your opinion of the price, right? So you'll still have access to that historical data.
All right. We have a clarification question. We were told yesterday by CRMLS that we can display compensation on outside sites, so long as compensation was not discussed on the MLS. Why can't it be shared on sites like Showing Time, for example?
Because that's inside the MLS. Showing Time is a product that is paid for by the California Regional Multiple Listing Service. It consumes the data from the MLS. Showing Time does not work at all without our data in it. And that's the specific phraseology they use in the settlement agreement, that we cannot send our data to a platform that has any types of offer of compensation. So here's the thing, guys. Let it go. Let it go. There will be no sharing of compensation between brokers from August 13th forward. Get over it. Stop trying to find a way around it. By the way, you're going to get crushed if you guys try to continue to share commissions, by the way. You're going to get crushed from a market share perspective. Think about what that experience is if you want to keep the old way, right? If you want to sit on top of the old puck way back on the defense side, you can. Realize what that means. That means you got to go into the seller and you've got to tell them that the amount of money they're going to pay you is double what they're going to pay me. Because that's the only way you can share commissions, right? You got to get the top number so that you can take half of it and offer it to the other side. How many of you think that the seller sitting there listening to 3 listing presentation is going to go with the one that is double the other listing presentation? Realize the people who hold on to that old system, you're not going to get a listing after August 13th. Not if you're in competition with another listing firm who does it the consumer centric and the new way, because the amount of money that the seller is committing to is half. You don't think that's going to win the day when you're pitching a $2 million listing?
And that was the core of the lawsuits, right? And it's the core of the DOJ's involvement in all of this from day one. They do not want commission sharing between brokers. It's non-transparent. They want it to be negotiated between buyer and seller. And that's what the settlement, that's why we lost, right, as an industry.
Correct. And I know some people are complaining about my harshness. Get over it, right? This is me training, right? If you guys want to stay in this business, then you better abandon the concept that you got to figure out, how do I share commissions in the new world? You don't. That's the answer. And it's so much easier the new way than the old way. It's simpler, it's more direct, and it's the way it's going to happen.
And frankly, as much as we've been talking about this at CRMLS truly for years, I'm still amazed at the number of people who come to me every day and say, well, if it's not published in the MLS, how much I'm getting paid, how do I get paid? Right? There has to come a point when we have to accept that it's not going to be, that things are going to be different. And saying it politely, it hasn't worked.
Chris, I've been saying it politely for 3.5 years.
I know. And I'm sorry, I didn't mean to come across that way, but what we want for you guys, for every one of you guys, is to be successful and thrive in the new way. And the only way to do that, to be able to thrive, is to accept that things will be different and to move forward and do it differently.
And guys, they're going to be different. They're going to be different in the next 30 days.
Right. It's coming.
The light was 3 or 4 months ago.
Right.
We are 30 days out from this changing. And if you're still wrestling with, how do I do it the old way? You are way, way behind the ball.
Yeah.
All right, we got it. We got it. Thank you. I like that because, hey, look, there's no avoiding it. Don't avoid it. This is what it is. Accept it, adapt, and move on.
Right.
Okay. We have a lot of questions about the forms, which, you know, I'm gonna try to address the ones that we can kind of dovetail in, but some of these I'm not going to ask because, as Chris said, this isn't the forms class. But at what point do I need a listing agent to get a BRBC signed? Many brokers are anticipating that buyers will avoid BRBCs by paying commissions by going directly to the listing agent.
I've heard that one a lot. I don't anticipate buyers going directly to the listing agent any more so than they did in the hottest sellers market that we just came out of. Right? This was the reality that already existed. Buyers have always participated in the payment of these fees. Again, this is our job to educate our customers, right? Our consumers. And that's why I'm strongly recommending that from this day forward, every CMA you do an adjustment for what the seller paid for the buyer's agent and for any other concession, right? This has always been part of what was baked into the purchase price. Okay. So will some buyers go directly to the listing agent? Sure. But isn't that exactly what we had in 2021 and 2022? And again, that is the decision then of the listing agent, right? Are you going to go forward with the transaction with the buyer being unrepresented, which you can do? And in fact, I like that CAR modified the listing agreement to accommodate for the fact that you could charge an additional fee to the seller because you're going to spend extra time, energy, and effort working with an unrepresented buyer. Remember, the buyer does not have to have an agent. You can buy a home without an agent, right? So the listing side has to make this decision, right? Are you going to represent your seller in the transaction, but still honestly deal with the unrepresented buyer? Or are you going, does the buyer want to also hire you under a separate buyer representation agreement to do a dual agency situation? By the way, you need to go back to your seller and get permission for that. Okay. So, you know, will that increase a little bit? It might, but I don't think it will take off just because of the immense value that buyer agents bring to the transaction. I think in our world, I mean, come on, let's be honest, right? People pay an extra 15 or 20 bucks because they don't want to take 10 minutes to go to the local restaurant and have it drop, you know, have food dropped off at their front door, right? We live in a service community, and people really value what a buyer's agent brings to the table, especially on the largest purchase they're ever going to make. So there could be a very slight uptick in the you know, people using a single agent, but I don't see that being very prevalent.
Well, and a follow-up to that is that one of the hesitancies agents have had in the past in California in particular is that, well, I can't get a buyer to sign an agency agreement or representation agreement because nobody else is making them do that, right? This is nationwide. Every buyer will have to have a representation agreement before they can be shown a house. So that you no longer have that excuse, well, I can't do it because no one else will make them do it. Everyone's going to have to do that. And talk about a little bit of the enforcement, Ed, on that. Who's going to enforce that? Like,
yeah. So you guys are going to help us enforce that. This is kind of like the clear cooperation policy. You guys love reporting clear cooperation policy violations, and it makes sense, right? When you have a clear cooperation policy violation, right? Someone who has listed a property as advertising it's not in the MLS. The reason you guys like reporting it is the agent that violated that rule is damaging the relationship you have with your buyer, right? Because the buyer hired you to represent them in finding properties. Here's a property that they come to you and get information on. You can't get information because it's not on the MLS. Now the buyer has this decision. Do I go to this other agent instead of you, right? You might lose a client because of clear cooperation policy violation. So because of that, you guys happily report those. This is the exact same situation, Chris, right? If Pete comes to me and says, hey, Ed, I want to go look at these 3 homes on Saturday. I explained to Pete what a great agent I am. I talked to Pete about the fee that I charge. And I explained to Pete that under our rules, that we need to enter into an agreement for me to represent him and go show these properties. And then Pete kind of gets mad at me. He goes, what do you mean, Ed? Last week, Chris showed me 3 houses last Sunday, and Chris didn't make me sign anything. Well, what's happened now, because Chris violated this rule, Pete and I are now in conflict, right? By Chris violating the rule, I may lose Pete as a client. Pete now thinks less of me because he doesn't know who's right, Chris or Ed. He doesn't know. I am turning Chris in. I'm sending that into compliance@crmls.org, and I want CRMLS to go hammer Chris, because it's not fair that by violating the rule, Chris has damaged a relationship between me and a potential client. There's another reason, Chris, that everybody's going to do this. Very few people are talking about this, but you do know that everybody in this room, because you're all realtors, you're all getting a release from liability because of this settlement. You are covered under this release. What a release means is that someone else can't sue you in the future for these claims about this conspiracy and on this case and they are lost, right? Realize individual agents could have been sued.
And some were.
And some were.
Yeah.
And individual brokerage firms were sued. Many of those were sued. And the brokerage firms are also getting releases. And other than 94 specific ones, I'm going to put that little group aside. Realize the definition of a released party under paragraph 18B says that for realtors, individual realtors, and for brokerage firms to be released, they have to commit to the practice changes of paragraph 58, 6 through 10. 58.6 is the rule we have of buyer representation agreement before you show a property. So in other words, if you're an agent and you go show a property without a buyer rep agreement, you are not covered by the release, and you can be sued by these plaintiffs or another plaintiff, and you will have no coverage under the settlement agreement, as will your broker. Your broker will also lose coverage. So there's a massive incentive for you guys to follow this rule that has nothing to do with the MLS, and that is your own pocketbook.
All right. What if a seller checks yes for concession, but during a request for repairs, they decide they don't want to offer a concession?
So remember, this is what's great about concessions. Concessions is not an offer. Concessions is simply an advertisement. It's kind of like, a list price, or let's say the price I have includes the refrigerator, right? Normally, a refrigerator is not part of a transaction, right? And I say, hey, if you want the refrigerator, right, I'm including that in my MLS advertisement. But you realize you have to put the refrigerator in the included section, right? It doesn't happen automatically. That's how concessions work, right? So the concession is not an offer from the seller. It's an advertisement that says this particular list price anticipates me paying some portion, of the buyer's costs. It is up to the buyer to decide. It's the buyer that has to make the offer that includes the concession.
And remember the language. The language says consider, right? It doesn't say commit. Right. So it's not a commitment to offer that number. It's a consideration. We will consider it if you present that and we negotiate.
Now, that being said, we still do have an inaccuracy, right? You have to be accurate in the publication of your listing. And we have another rule that many people don't know about in the MLS. And what this rule says is if you're a listing broker, this is a rule on listings. If you're a listing broker and you put the terms of an agreement or the terms of a listing, right, into the MLS system, and your seller refuses those terms, you're required in the multiple listing service to advise everybody in the agent comments, my seller will not do a deal under these terms. That's a requirement, and you will be fined if you don't do that. We see this, and we've enforced this on price before. right? We've had situations where someone would list a property, let's say for 800,000. And it's actually a property that's value, its true market value is like 1.4 or 1.5 million. And the agent was putting it in at 800,000 because they wanted the leads that would come from all of the advertising of a clearly $1.5 million property being listed for 800,000. And then what happens is somebody puts an offer in at, let's say, 900,000, all cash, close in 10 days. And the seller says, no, that's too low. We will send a violation to that listing agent. You do not get to lie on your listing to drive traffic. So Chris, we do have that. We also have the misrepresentation rule that you cannot misrepresent your listing. So Pete, it's one of those scenarios where if there's some legitimate reason why the seller is saying, I'm not going to offer the concession. Let's say the price came in 20 grand or 30 grand less than the list price. Well, now I'm not going to offer the concession because you drop the price by 30 grand. I'm not dropping the price 30 grand and giving you the concession, right? I don't have to do that. Right? So that's where it all becomes part of the negotiation.
A practical question here. What if agents never return your call to let you know what compensation their listing may be offering?
Why did you call them? Why would you call somebody and ask what compensation you're offering? I don't care. Why would I care what Chris's deal is with his seller? This again, I know I'm talking harsh. Why would I call? Chris, you have a listing for $1 million. I'm representing Pete, who wants to buy a home for $1 million in that neighborhood. Pete, you and I are having a conversation. And Pete, you and I agree on X percent because I'm a great agent. You're going to pay me X. I'm going to show you Chris's property. I'm not going to call him. I don't care what his deal is with his listing, with his seller. And Pete, we're putting an offer in for $1 million. And in that offer, it's going to say seller to pay Ed Zorn Realty X percent of the purchase price at closing. We're done. Now Chris can call me back and he can send a counter offer. Guys, there is no offer of compensation. Also, if they use the CAR form, there is no offer of compensation. There's nothing for Chris to respond to me on the phone call because Chris is going to say there is no offer. If he used the CAR residential listing agreement, it's gone.
All right. What about realtors holding an open house for a different broker's listing? Is it BRBC or OHNA required?
It is call your lawyer to defend yourself against losing your license from the Department of Real Estate. That's my first piece of advice for you. Okay? Because I'm not exactly sure why you're doing that. Now, if you're going to do that, there's a lot of written documentation that has to happen and all of that. So that one I'm not going to answer. I'm going to tell you, you better have a lawyer involved if you're going to do that.
Because the DRE is looking.
They're very clear.
You've made it very clear.
That's a go talk to your lawyer and your broker before you do that. Because that needs to be approved at that kind of level.
All right, the questions keep pouring in, so I'm going to try to hammer away as many as we can here. When you get tired of us, me, Ed, just let me know.
No problem.
Does the listing agent have any responsibility to ensure there is a buyer-broker agreement signed for showings?
No, that is not the job of the listing broker. I understand the SPBB has that whole concoction of sharing it. I don't know why they do that. It's not necessary at all under any rule, under any code of ethics. It is not your job as the listing broker to confirm whether or not someone has a buyer-broker agreement or not.
Okay, you covered this in that breakdown of how the commissions go, but again, there's a little bit of confusion, so I was hoping you could address it. We've always had to describe concessions as non-recurring closing costs only. Due to lender allowance requirement use of funds. How will that work?
So that's a good question. So we have to separate the word concession on how we use it in the industry in its broader sense of a seller paying a fee for the buyer and go now down to how do the Fannie Mae, Freddie Mac, FHA define an interested party contribution. That's the phrase, interested party contribution. That phrase, we call them IPCs. That is the limits that you're talking about here, right? FHA at 6%, Fannie Mae, it depends on how much you put down, and it's a structured system. What all of those rules say, and by the way, NAR has confirmed this in writing from every one of these entities, is that Fannie Mae, Freddie Mac, FHA, VA, they will not count against the IPC limit any amount that the seller pays for the buyer's broker fee. That does not go against the limit. Okay, and the reason for that is if you look at the actual, and I've looked it up, I actually, somewhere in my paperwork here, I have the regulations from Fannie Mae. It says that anything that is traditionally or customarily paid by the seller in the transaction for the buyer is not subject to the IPC limits. And obviously, for decades, sellers have been paying the buyer's fee. And so all of these entities have confirmed that those will not be. So let me give you an example on an FHA loan. Let's say that, and I'm going to use a real number here. Don't freak out. Don't leave the webinar, right? This is not, I'm not saying this is a fee everybody has to do. I'm just using this for an example with actual numbers, okay? If Chris has a listing and I'm bringing Pete to a transaction, and in the offer, Pete says, seller to pay Ed Zorn Realty 2% of the closing price. And Pete says, seller to pay 2% of the non-recurring closing costs, right? And Pete says, seller to pay 4% of origination points and loan discount points. That loan goes through. We're under the IPC cap, right? Because the part that gets paid to me as the buyer's agent is not part of that calculation.
All right. This is kind of a paperwork one, but should be easy enough. Is a buyer broker agreement a blanket agreement, or can there be a new agreement for each property shown?
That depends on how you want to write it out. I would assume most of you will do a blanket agreement, right? That's what I do. I can tell you I signed 2 buyer rep agreements here in Tennessee in the last 2 weeks. I got one of them in escrow so far, so that's good. The other one I'm still hunting for. I signed them, right, for the duration of a period of time and a market area, right, an area that we're looking at, and I describe the kind of property they're looking for. Or if you prefer, you can limit it to specific properties, right? That's the freedom of contracting that you can do as a buyer's agent.
You could sign a buyer representation agreement for one showing today, and that's it, right? You have all the way up to an exclusive, right? The default for the buyer rep agreement non-exclusive is 3 months on the revision that just came out. I just looked at this morning.
All right. Will the buyer be able to negotiate the concession amount?
Absolutely. Right. So even if there's no advertisement for a concession, you can still ask for whatever you want to ask for. And it just becomes a portion of the negotiation of concession against purchase price. By the way, this system, the reason we know this new system will work totally fine, it's what works in commercial. You realize in the commercial world, there's no multiple listing service. There is no set offer of compensation, right? We have to put how we as a buyer agent are going to get paid into the transaction, right? And so this is a very normal thing that we do in the commercial world. And what you find is as you start negotiating other terms and other fees and costs for the seller to pay, if the seller says no, all you do is change the purchase price a little bit to accommodate that no, and then they say yes. So that's all that's going to happen, is this will become just a flat piece of negotiation.
Okay, I like this one. When being a listing agent, can your private remarks mention the words, quote, buyer's agent commission friendly, end quote, without saying the amount or percentage to indicate the seller is willing to help pay their agent?
Oh my God. Why? Why would you do that? Number one. Two, I'm going to take it out and issue a fine to you.
And again, I'm going to make this statement because I have to make it every day, right? Is that CRMLS is not trying to be punitive here when these fines come out. The only way to stay under the settlement agreement is if they proactively enforce these rules. So for all of our benefit, if CRMLS doesn't do that and gets sued big time and we lose our MLS, we all suffer from that. So it has to be done.
And I'm going to suggest to you, just to finish the point, that person, whoever said that comment, cannot use the CAR form agreement. So I'm assuming that person made a different agreement, went to a lawyer, had a lawyer craft a different document. Because again, under the new CAR residential listing agreement, they're not buyer compensation friendly. They can't be, because it's not accommodated in the contract.
That agent would use the concessions field.
They could, right? That's the easy answer. And for anything that the seller would want to do, right? Is the seller, I'm friendly on giving you a upgrade for my ugly carpet to be replaced. I'm friendly to pay for your escrow and title fees. I'm friendly to pay for a loan origination point, right? That's exactly what the concession field's for.
All right, I think a lot of these are kind of in the same vein here. We're just having trouble wrapping our brains around this is the new system. And, my interpretation is people are looking for ways to make the old one work, which, you've been straightforward, and that's just not the case. But
Well, and that's it's not just it's not just the guys here, right? Remember, CRMLS or CAR introduced or planned to introduce 19 forms on June 25th. And the Department of Justice stepped in and said, right? Those still include brokers sharing commissions. And those had to be changed. And now CR's position, I was on a call Wednesday with the CR attorneys and got a sneak peek at these forms. And they basically, they flat out said, we are not going to be in a position at CAR to participate, facilitate, encourage, be involved in any way of brokers sharing commissions. That's why the forms have been changed the way they've done. And that came as a result of the DOJ stepping in and saying, you will make these changes.
And let me address the kind of the harshness of our tone. Guys, we're 30 days out. 30 days is all you get. And the time is now to change your mindset. So there is no answer to any question that starts, how do I share whatever follows? There is no answer. The answer is don't do it. That's not how the system's going to work anymore. So we're trying to move you from what you've done for decades to a new system in less than 30 days. So I wish I could be gentle and kind and sweet and, move through it. But the reality is the time is now that it's different.
I'm 44 years of using the same system, right? And have to change.
All right. Does the rule regarding brokers being unable to share commissions also govern referral agreements?
No, that CR answered that question on Wednesday. Yeah.
Okay. I need clarification on a listing agent holding an open house, potential double ending a deal, but not having compensation agreement in place with prospective buyers at the onset. Not having a buyer agreement for anyone walking the door certainly seems easiest and most practical, since theoretically many will have agreements in place with their brokers already. But what would be a best practice?
So again, I think the best practice if you're going to hold an open house is that you're there representing the seller. That's your relationship. That's your fiduciary duty. That's who the person's giving you permission to let those people in the home. And that would be the context under which I would hold myself out to if a potential buyer came into the open house, showed an interest in the property. I would let them know I represent the seller. That is my client. And then the conversation I would have with the potential buyer, if they get to the point where we would like to make an offer, at that point, it would be what kind of relationship does the buyer and the listing agent want to have? And there's two choices, right? The buyer can be unrepresented, or the buyer can hire the listing agent as a dual agent. But before that relationship gets consummated, you need to look at your listing agreement. You need to look at what permissions do you need to get from the seller. You need to evaluate what is your broker's policies on doing dual agency, right? So that is something that you need to talk to your broker about, and based on the policy in your firm, because there's many different ways to handle that relationship.
And CAR has a new form they just came out with. I don't remember the acronym for it, but it has to do with buyers coming into an open house. You can have them sign essentially a non-agency form saying, I don't represent you, sign here, right? Which may be difficult to get, but that's part of the CAR training that you'll be able to get when you take the classes on the forms, is they address that exact question. And they do have a form for that if that's what you and your broker decide you want to do.
And by the way, if I could just wrap this up from an MLS perspective, when you close out the listing, when the buyer's unrepresented, even though you may have helped do things for that buyer, we do have when you've got to put the buyer agent in, we do have an NONE, right? So that is one of the buyer agents you get to pick, is that there was no buyer agent. It's not you. So remember, if you're going to close the listing out, don't put yourself in and make it look like you were the dual agent when you're not, because I'll be honest with you, as a lawyer, I have represented clients in cases where the buyer was really unrepresented, but because they closed the listing out and put themselves in on a double agent deal, the plaintiff attorney used that fact against them in a subsequent arbitration. So don't do that, right? Be accurate. If the buyer is unrepresented, then use none in the MLS when you close the listing out for buyer's agent.
And the question I just see in the chat, I know that we should be doing at the Q&A, is, does the unrepresented buyer walking into an open house have the option of hiring a different buyer agent for that property? You said two options were dual agency and unrepresented. Of course, that buyer always has the option to have their own agent. And yes.
Okay, what if the seller will not pay the percentage of commission you have stated on the buyer broker agreement, but the buyer can't afford to pay it? Do you then drop our commission or work for free?
I would never work for free, so I would say no on your hypothetical, and the seller will pay it. You just have to adjust the purchase price. So if the question is, we're at the top, right? My client, so I put an offer in at the very, very top number that my client can get. And in that offer, the seller says, no, I'm not paying the buyer's agent. So first thing I would do is I would look at what was the offer we made in relationship to the comparable properties. And is the seller overvaluing their property because they're using comparables where all three comparable properties, as an example, the seller did pay an agent and did pay some kind of concession? Is the seller on the property that I'm the subject property I'm making an offer on wanting the same value? Well, then I'm going to put a CMA together, send that to the listing agent, and explain that the offer that we made is a valid, strong offer in relationship to the comparables. That's the first thing I'm going to do. I'm going to fight. But just like what happens is if you have a buyer and you're in a bidding situation and some other buyer bids $25,000 more than your buyer can afford, then you go to a different property because your buyer can't afford that property. If the buyer also doesn't have the cash to pay you, I would not, quote, work for free. It's the dollar and cents that happens on any other situation where you have a buyer. I'm assuming everybody in this webinar has had a buyer who's wanted a home that they can't afford. Right? This is just another situation where they can't afford to buy that house that they wanted to have.
And I'm going to just jump in and say this again, because I know this comes up. I'm going to call every 2 weeks with CR attorneys, and this comes up all the time. And it involves the DRE as well. About a year ago, the Department of Real Estate came out and said that holding an open house, having someone else hold your open house open, your listing, is a violation of the DRE rules. They came out pretty harshly and said that. They backed off since then. However, they will make a statement. Their belief is that an agent cannot work for two different brokers. You're licensed to one broker. So if you're holding a house open for another broker who's engaged by the seller to represent them, you can make an argument that you're working for two brokers, right? And number two, from a business perspective, I don't allow my agents to have anybody else hold their houses open. That seller has hired my firm, my agent, to represent that property. And if I have someone from another firm hold that house open, what does that say about my ability to complete my task for myself? And the third is check with your E&O insurance, check with your broker, because a lot of E&O insurance companies will not cover the transaction if the person holding a house open is not a covered buyer, or not a I don't know what the term is, Ed, but it's in the insurance, it's you're not working for that broker. So if there's a lawsuit, you're not employed by that broker who has the insurance. So therefore, there may not be E&O insurance.
Not even be in coverage. Right?
Yeah, for either buyer,
right.
Right, either side, it's not good business practice, and the DRE is frowning on it and may look at that more harshly as well.
All right, questions are still coming in. Gentlemen, thank you so much for your patience. What if a buyer signs a agreement with you at 3% and the property they want to buy is offering 1%?
So again, these numbers are example purposes only, and we're not saying this is what the standards are. The good thing is in Southern California, guys, we have such a huge range of offers, as you guys know, that we don't suffer from the Missouri problem that got that lost the case. But in that example, make the offer. Make the offer, put seller to pay your firm 3% at the purchase price of closing, and then start negotiating.
But if to that, the buyer's responsible for that 2% unless you renegotiate with your buyer. I mean, right? You have
right, but I think what you, and again, don't be afraid to move the purchase price. People get concerned like, well, what if the seller says, no, I'm not paying more than 1% towards a buyer's agent? Increase the purchase price by 2%. The seller's not going to say no to that, by the way, right? The seller's getting the identical net.
So another question, I know Pete and I were going to alternate because we're going back and forth here. Question is, should we include an SPBP when we submit an offer to the listing agent? You can only do that if you have a buyer representation agreement signed. So if you don't have a buyer rep agreement signed, well, first of all, how are you showing the property? But you can only do that if you have that signed. So yes, if you want the seller to give a concession to the buyer to pay your fee, then yes, submit that form.
Yeah, when I say the words put in the contract, seller to pay at Zorn Realty X%, right? You can also use, I believe it's check the box G3 on the RPA and attach the SPBB if you like those extra pieces of paper. Yes, you can do it that way.
Okay. There are brokerages not included in the settlement agreement, so they are not bound by these changes. Will they be allowed to put offers? Will they be allowed to put offers of commission in remarks or someplace?
No, that's not a true statement. The MLS rules have changed. So even those giant brokerage firms that haven't settled their claims yet, they're not released from anything, but they still have to follow the CRMLS rules just like everybody else. So there's not two sets of rules, one set of rule for those guys and a different set of rules for this. And by the way, the buyer rep agreement issue, even though the firm is not released, each individual realtor in each of those firms is released. Okay. So the power of the buyer rep agreement needing to be signed before you go show a property, or you're not released from the lawsuit, that applies to each individual agent. And again, I don't believe EXP has settled yet, is my best understanding, to use an example. Okay. Every EXP agent is released from these claims under the NAR settlement, even though EXP as a brokerage firm is not released.
Okay, there's several questions here. You covered it before, but clearly there's some confusion because it's coming up multiple times here. So why did you say that a buyer can come and buy a home with no representation, but at the same time, every buyer needs to sign a BRBC? So you're saying if a buyer has no representation, you can let them into your listing and they write their own offer?
Yes, exactly.
Yes.
That's exactly what I'm saying. Yes.
Any buyer, any person can represent themselves. You just can't represent someone else without a license.
So let me give you an example. Maybe it's a little more concrete. In 2 weeks, my wife and I are flying to Florida because we're looking at some condos we want to buy for some vacation rentals. I've been a real estate attorney for 30 years and a realtor for 20 years. I've done 1,000 transactions. Now, I'm still going to hire a local realtor because I want to know and I value their local expertise. But I can tell you, I'm not going to pay what a first-time homeowner is going to pay for that realtor, because I don't need help negotiating the transaction. I don't need help deciding what price to put in. I don't need help with the due diligence. So I may command a different price, but let's just say I knew the area. Look, let's say it's an area that I was very comfortable with, or maybe I grew up there or something, right? I could do the transaction perfectly fine without a local realtor representing me. And so I can still call the listing agent up and then go see the property and tell that listing agent, I want to offer this amount, put it into the standardized form. I'll read the form, I'll sign it, and let's go do the transaction.
And it's really a kind of a sticky situation. On the call Wednesday, Brian, who's the chief counsel, I guess now for CAR, was asked that question about, can you as a listing broker provide CAR forms to a buyer on your transaction who's going to represent themselves? And the question kind of surprised me a little bit. He said, yes. Now, you're not allowed to give the blank form so they can copy it and go do other transactions, but you can fill out some basic information about the property and give that to a buyer, and they're perfectly free to write their own offer. It becomes sticky, and there are forms to make sure that you don't represent them, and there's implied agency, and there's a lot of things that go into that. So none of us here are advising you how to do that. Make sure you take the CAR training class on those forms and ask that question of the CAR attorneys.
Okay, sorry, I'm answering some questions here as I read them through. Covered that already.
Can I deal with the one you did one? There's a question that said, did NAR ever consider that this will eliminate buyer agents?
Yeah.
That most buyers will not want to sign anything to see a home, and that most buyers will simply go to the listing agent. Yes, NAR consider that. They very quickly dismissed that, because while this is like really new to us here in California, realize there are 18 states that have already had mandatory buyer rep agreements. When I go to some national level conferences, I talk to some agents that scratch their head and go, what's the big deal? Like, why are people concerned about the buyer rep agreement? Because they've always worked in an environment where every buyer has always signed a buyer broker agreement. So they don't understand why it was even included in the settlement, because to them it's obvious. Who in their right mind would go to a house without a buyer broker agreement signed? Like, that's how they talk to me. They're like, they don't understand why that was included in the agreement, because in their world, they've never opened a property door without having a buyer broker agreement signed. And I have to explain to them that there are areas across the country that are different and that this is not done. So I know there's a fear out here that this is going to be super hard to get buyer rep agreement signed. I'm telling you, it happens all over the country constantly. In fact, if you look at the NAR statistics, 54% of all closed transactions across the country have a signed buyer representation agreement to them. So this is not some kind of like super uncharted water, and there's no way that a marketplace will survive with mandatory buyer rep agreements. This has been done for decades in other locations.
And the good thing for us is that everyone's going to be on the same level playing field. You're not going to have to worry that someone's going to go down the street and go to a different agent who's not going to make them do that. So
Statewide,
make it much easier.
right?
Countrywide.
Nationwide.
Like literally, this is the same rule everywhere in the United States.
Yeah.
Can a concession be negotiated outside of the RPA and brought into the mix at the RR?
I guess theoretically, I have no idea why you would do it that way, but theoretically.
Yeah, it all kind of depends on what that before. But yeah. Well,
it's one of those scenarios where if you're asking for your broker buyer fee, you should do that when you make your offer, right? The RR is about repairs, right? So if you do an inspection and you find out that there is a problem, can you, in the middle of the transaction, modify the agreement to add more money to the concession that a seller is providing? Absolutely. But I'm not sure I would wait and ask for your buyer representation fee at the inspection stage. You're going to find you will probably end up not having the seller pay that fee if you wait until that point.
Okay, can you explain why there's 2E2 on the RLA if the seller cannot offer compensation?
You have to look at the form.
You know what? I've got it. I'm sharing, I think, right now.
Okay. So what number was that?
2E2.
In the listing agreement?
Yes.
This is the new listing agreement.
It's about photos.
Yeah, it's about photos.
Maybe he was looking at the old one.
Maybe 2C2.
Perhaps it was E in the chat, but perhaps it was meant otherwise.
So yeah, maybe if it's 2C2, 2C2 is about the additional compensation to seller's broker if buyer is unrepresented. This is, again, very typical in some agreements. This is what we call a kind of a dual rate commission. And here's the idea. Chris has got his property, $2 million, where I'm going to list it for him. And we talk about, hey, Chris, as a seller, the most likely scenario is the buyer who comes to your home is going to be represented. And that's great for us. We want there to be buyer representation, okay? Because when a buyer's represented, that buyer's agent shows them the property. That buyer agent makes sure they're properly qualified for a loan. That buyer agents make sure that they have the money to put as a down payment. The buyer's agent's going to handle the appraisal access, talking to the appraiser. They're going to handle inspections and repairs. So we have this great benefit, Chris, of this work being done by this buyer's agent. But if a buyer comes and wants to put an offer in on your property and they don't have an agent and they don't want an agent, I can help the buyer still put an offer in on your property, right? I can take instructions from the buyer. I'm going to represent you. I'm not going to represent the buyer, but I can fill the form out and put a dollar amount in and have them sign the form and get it to you. But realize I, as your listing agent, have to do a lot more work if that buyer's unrepresented. I'm now going to have to come here to let the appraiser in. I'm going to have to come to your property and sit here for 2.5 hours while the inspection takes place. I'm going to have to communicate with a lender to make sure that the guy's properly qualified. I'm going to have to answer questions to the lender. You guys all know, right? There's probably going to be 3, 4, 5 hours more of work that I'm going to have to do in representing you, Chris, as the seller if the buyer's unrepresented. So if we end up with an unrepresented buyer, Chris, I'm going to charge you an additional X% to cover that extra time that I'm going to have to put into that transaction. So that's the purpose of 2C2. It is not compensation going to another agent. It's compensation going to the listing agent to cover the additional time, energy, and risk associated with doing a transaction with an unrepresented buyer.
Man, looking over these questions, there are so many about the paperwork. So as much as I'd like to address those and bring those up, this just isn't the forum for that. We do have some upcoming classes, as I mentioned. Check out our calendar at nstcrealtors.com. Store.car.org has a bunch of classes coming up. CRMLS, Ed posted the link. We have lots of resources there, but I'm sorry I'm not ignoring you, but this just isn't the place for those sort of questions. Unfortunately, because we have 54 questions to go.
And again, CAR attorneys are the ones that should be answering the questions about the CAR forms, right? They're the ones doing the training on that. This is the integration between forms and MLS rules. We're trying to bridge that gap. That's what today's about.
Oh man, this is a can of worms, but
sometimes those are the funnest ones.
Well, you've explained it several times, but I guess obviously there's some misunderstanding. How will the buyer's agents get paid? Be more specific.
I'll be real specific, right? And so how's a buyer's agent going to get paid? It's actually simpler now. So Chris is my buyer, okay? And Chris and I negotiate the fee that I'm going to get paid. And it's X. That's the amount. And we sign a buyer representation agreement at X. I show Chris and his wife properties. They find a property they want to put an offer in on. And we talk about a CMA. I make a CMA for him. We talk about the value of the $2 million property he wants to put an offer in on. We decide that at looking at it, that $2 million, we looked at comparable properties. There are 3 other comparable properties at $2 million. In each of those comparable properties, the seller paid for the buyer's agent and some other costs. We put an offer in at $2 million. In the offer, in the document, it says seller to pay Ed Zorn Realty X% of purchase price at closing. We do the transaction. The seller signs it. I do all the normal repair, appraisal-y stuff, shepherd us through the closing. I end up with a check from the escrow company, and the closing statement looks just like it does today. On the seller side of the closing statement, it has a payment to Ed Zorn Realty for X%. That's how I get paid. I will get my check through escrow on the seller side of the transaction.
All right. A little more straightforward. Does a BRBC still apply for showing a rental property for a client?
Hey, let me hold on a second. Let me go back to that because one of my agents has a transaction in escrow right now where my agent has a buyer representation agreement for X%. And the commission instructions through escrow are that the seller to pay our brokerage Y, and there's separate commission instructions that the buyer will be paying our commission, our brokerage, a different number, making up that gap. So just as an example,
X minus Y.
X minus Y, right? So my agent is getting the full number that he signed the buyer representation agreement. The seller's paying a portion of it, and the buyer's paying the other portion of it through escrow. So that is possibly how it could happen as well.
And I think that, Chris, that's very possible, more likely on those more cash transactions, or those transactions where someone's coming in where they sold another property and they're maybe putting 50% or 60% down, and the buyer would prefer to have a lower purchase price for maybe taxing purposes, insurance, or some other purposes, right? So that
we're transferring property tax basis. Yeah.
Yeah, exactly.
Whatever.
Yeah. So you can definitely see that being part of a way that you also get paid.
If we're using the price for concessions, how you address the appraisal?
The way you address the appraisal now, again, the current
Held out, right? It would be pulled out in that concessions breakdown field.
correct. And realize, guys, this happens now, today. If you look at $1 million property and there's an offer of compensation today on a property of X, the seller paid that amount to the buyer's agent. That's already happened. That's already baked into the price. So you shouldn't have any different appraisal problems than you do now in an increasing market, right? It's the same thing. The seller's still paying the buyer's agent inside of the transaction. Nothing is changing. The only difference that we're doing, really the really most significant change, is that number that the seller is paying for the buyer's agent is now going to be set by the buyer and the buyer's agent, and not going to be set by the listing agent and the seller. That's the biggest change that you're going to see, is who sets the price that the seller pays to the buyer's agent. Everything else is pretty much going to work the same. Just the form you use is going to be a little different. That's all. It's actually not really that much more complicated than that.
So for good buyer's agents, this is really a blessing if you think about it.
Fantastic for good buyer agents.
Right? You as the agent determine your fee, not the listing agent.
Yes.
Why would the listing agent be the one to determine how much you're going to get paid? If you just shift the mindset, it's really an opportunity for a good buyer's agent.
It's fantastic for good buyer agents.
Okay, a couple of these questions came up about appraisal, and so I'm just trying to find the best one that kind of, so here we go. What do you suggest if you raise the purchase price by 2%, the property doesn't appraise, and the buyer can't pay your commission?
So I guess my question would be, this is why I would put the commission in the purchase agreement. Right. So if my offer says seller to pay at Zorn Realty 2%, it's already baked into the deal. So I would treat it just like any other property that doesn't appraise. I'd go to the seller and say, look, I have an appraisal contingency. It didn't appraise. It didn't appraise because your house isn't worth what we put the purchase price at. So are you going to reduce it to what the value of the home is or not? And you're going to treat it just like any other property that you put an offer in and it didn't appraise. Right? The process is absolutely identical.
Okay, excellent. In a previous statement regarding listing a property in the MLS at a lower price that the seller won't really sell for, your 800, 900 example, will this prevent a certain agency, we won't name them, from using their low price auction platform to draw in leads at a low price?
So auctions are different than a regular sale. So as long as it's truly an auction, The rule in CRMLS is that any price for an auction property has to be the price that the seller will accept. So if you see a listing where there is a price and you've gone to that auction or participated in that auction process and you've been told, no, that price is not available to you, please report that to the MLS, as we will conduct an investigation on that. And we have had I can think of 2 over the years that we've actually forced them to change their system so that they can't do that bait and switch kind of mechanism. So that is an MLS rule violation. But I need you to report that to me so that I can, take the appropriate action on that.
Okay. Can a buyer be unrepresented if they are in a signed representation agreement with a buyer's agent? If not, would the listing agent need to verify?
So that's an impossibility, right? What unrepresented buyer means is they have not signed a buyer representation agreement.
Perfect.
And if you look at the new buyer representation agreement, it says very clearly in there, asking the buyer, do you have any other obligations? Have you signed any other agreements, right? And it's really, it's emphatic to try and make sure that buyer's not being committed or obligated to 2 or 3 different brokers.
Yeah, and that's something, that's a good training point for all of you.
Right.
You really, really need to make sure you're asking your buyers if they have signed any other agreements and whether those other agreements are exclusive or non-exclusive. And you really need to make sure if they have signed another agreement, before you show them a particular property, you need to ask, have you ever been in this property before with another agent? Because specifically the showing of a property and the touring of a property under the BRBC is a triggering event for that other agent to get paid. So you guys should anticipate talking to one another as competing buyer agents, right, on non-exclusives. If that client wants to go see the home a second time with you that they saw with someone else, right, you may need to send them back to that other person and say, hey, I can show you new homes. I can show you homes you haven't looked at before. But you have an obligation to this other agent.
And see, here's this whole paragraph. Properties excluded from representation, advisory regarding buyer signing multiple representation agreements. So just, again, take those classes, look at the forms. A lot of that will be answered for you.
Okay, Chris, there is one in the chat or in the Q&A that was directed towards you if you want to scan down and look for that one. In the meantime, here's a relatively straightforward. What else can concessions be used for besides buyer commissions, closing costs, and renovations?
The other category that we see pretty typical is financing costs, right? Where the seller pays some kind of point for origination loan costs or for discount points. In fact, I know about 1.5 years ago, there was a very prevalent program that had to be paid by the seller. So this program only worked for the seller. It was 2%. And what it did is they took 2% and applied it to the first 2 years worth of payments for the buyer. And it drove down the qualifying number, right? So there was a very specific program. The reason I know that is my daughter used it, right? in a home she bought here in Knoxville, Tennessee. So that would be the other category, right? Those are the big 4 are, going to be escrow and title fees, going to be repairs or updates to the home. It's going to be loan discount points or origination points, or it's going to be for the payment of the buyer broker fee.
And there's a question about, does this apply only to realtors? What about non-realtors? Right.
So these are MLS rules. So whether you're a realtor or not does not matter. So even a non-realtor still has to get a buyer representation agreement before they show a property that's listed in CRMLS. The rules still apply to any licensee that accesses the multiple listing service.
Okay, so that question that came to me, that came directly from the chief counsel of CAR on Wednesday, was asked, can you as a listing agent provide the purchase agreement forms to an unrepresented buyer? And the answer was yes. So that's a question you need to save and direct towards CAR hotline or Gov or whoever, whatever class you're going to take it from, Jana. But that's what we were told specifically. What they didn't want you to do is give them a blank form, right, which could then be copied and used in other transactions. So if you filled out property address, different things like that, that according to CAR, you are able to do that on behalf of your seller because you have a buyer out there, right? They want you to sell the house and there is a real buyer.
In fact, one of the CAR licensing things, depending on what platform you're using, some of the platforms don't even let you print out a blank form.
Right. It's a
sample. There's an address in or something in it that
right.
You know.
Okay, I'm a small brokerage with no large IDX site that will have any impact when displaying concessions. I feel like this is just helping large brokers like Redfin, Zillow, etc. So I think what this person's getting at is where, if they don't, you don't need to have a large IDX site to display a concession on, you can just display it on a regular website, correct?
Right. There's no barring, there's no limitation against displaying a concession. So it will be part of the data feed. So that's just the distinction between having an IDX website versus not having an IDX website. I'm not sure how that really plays.
So let's say that they meant to type in commission instead of concession.
Those large firms can't display commissions. So as an example, Zillow has no listings. Anyone here go to a Zillow listing? I've never seen a Zillow sign, right? So even on Redfin, it would be limited only to Redfin listings. It would not be on any other listing. So you're never going to see an offer of compensation on Zillow. You would only see offers of compensation on Redfin for a Redfin listing. But again, if Redfin is using the CAR form, you won't see any offers of compensation because there are none.
All right, covering some of the same ground here, but again, they keep coming up, so I assume there's some confusion. I foresee that many buyers will simply work with a listing agent. How does the listing agent protect their legal status?
Talk to your lawyer and your broker. I think we've kind of have covered that a couple of different times.
Okay.
You know.
Yeah, you don't have to represent an unrepresented buyer as a listing agent. Or do it for free. I've gone through the questions too, and I think we've kind of worked through most everything that's not going to be repetitive. And again, we're going to encourage you. There's going to be lots of opportunities through the local association, through NSDCR, through CAR, through CRMLS. This is the first, guys. Hopefully this opens your eyes and it will go into these new trainings with a fresh perspective, right? And there's lots of opportunities to ask those questions of Gov, Neil, Jana, anybody at CAR on their forms.
Can I address one question? I think that's a pretty good one in here real quick before we close down.
Sure.
Someone asked, is there any chatter about how this may make it even harder for first-time home buyers to succeed? I think this is a good question. And I believe this is the only argument left for offers of compensation. That for those of us that have worked with FHA buyers in the past, we know that when you work with an FHA buyer, a first-time homeowner, especially someone maybe from a historically disadvantaged group or that has never had anyone own a home in their family before, we know that it is a 60% emotional event and only 40% about finances, analytics, right, rationality. And when you're working with first-time homeowners, there's a big fear factor, right? And them not knowing whether or not if they put an offer in, that they'll be able to get the home, because most of these first-time people, while the price of the home may be fine and they can qualify to make the payment, their problem most of the time is how much cash do I need to bring into the deal? Right? So there is definitely a concern about this changing. And this is why CRMLS is so adamant about the need to keep the concession field alive. We see through the data that FHA loans have a higher percentage of concessions. We also see that the average is about 1.8% in concessions above and beyond what the buyer representation fee is that's being paid on those same deals. So our answer to that legitimate concern of impact on first-time homeowners is exactly why we want to keep the concession field, so that sellers can say, look, buyers, I have an FHA type property or a condo, and I know you need help getting in. So I want to advertise as a seller that I'm going to help you get in, so you'll come to my home first. I think what we're going to see when we look at the use of our concession field, we're already seeing it. Realize 50% of the time, people don't put a number in the concession field. They just invite a concession to be put in. I think what we're going to see is that the people who do put in a dollar amount or a percentage will generally be more those FHA type properties, because that's the group that is the most benefited by that kind of advertisement. So I think it's a good point you bring up. Is there a potential negative impact in this change on the first timers? There is, just because of that emotionality of what it is to buy your first home. But by having concessions and offering that avenue to relieve that pressure, and in fact, I'm going to argue the concessions are better than the existing offer of comp field, because the only certainty in offer of comp is that my agent got paid. That didn't help me as an FHA buyer get my escrow and title fees paid at all. That's still an unknown, right? Now with concessions, the advertisement can include escrow and title fees also, right? It can be a larger number than what an agent's getting paid. And that's exactly what we expected. I would expect to see concession numbers of 4 and 5% on FHA properties. Now, no agent is getting anywhere near that money. That money's not going to the buyer's agent, right? More than half that money is going to go for other costs. That's what the numbers already that we have to suggest is going to happen. So I think that's a good question, but I want to make sure I take a little bit of time to explain the importance of concessions specifically for those first-time homeowners.
Well, and that's a good point, because this is CRMLS's rule, right? This CRMLS came up with this months ago, and I don't, correct me if I'm wrong, but I believe it was the first MLS in the country to do that. And I know that we have other associations or other MLSs around us that have not offered or modified their concessions field yet.
Correct. Right. There's fear, right? Because the consumer advocates, the Department of Justice, they're kind of rattling their sabers saying that concessions is just a replacement for commissions. It's not. And that's why I was so adamant in fighting that erroneous assumption based on no data, because we actually have data. That's why I did the slide with those examples to demonstrate it's not the same thing. And it's an important thing to fight for, because it is necessary and it is helpful for those first-time homeowners. And we don't want to leave them behind as we make these changes just because we're afraid of the Department of Justice or some plaintiffs' lawyers. At CRMLS, we're not afraid. We know we're on the right path and we're doing the right thing for those first-time homeowners, and we will take up that fight.
Excellent. Well, I can't think of a better place to wrap it up. Ed, thank you so much. Chris, thank you so much. A lot of great information. Again, thanks to everyone who attended today. It's a time of change, and people like you who are attending these webinars, staying on top of it, exactly what we need. So Keep up the good work. Check out all our resources between our website, CRMLS's website, and Smart Zone CAR's website. So yeah, more classes coming up. Stay tuned. Thank you everyone so much for your time, and have a wonderful day.
You guys.
Thank you.